This reform is one of transparency and safety.
There are still crimes that we cannot hold a person in jail for committing them pretrial, despite how dangerous they may be.
It's been a point of political contention for nearly 2 years, but this September, part of the SAFE-T Act that eliminates cash bail will become the law across Illinois. Some officials say they still have concerns about implementation after the state Supreme Court ruled the legislation was constitutional. But Cook County's top prosecutor and public defender called it a step in the right direction.
The reality is that we knew that this legislation was constitutional, and the reality also was that we had a bail system in place that was not necessarily keeping our communities safe, that was keeping people locked in jail pre-trial simply because they were poor and not a threat to the public.
The decision on who goes to jail or who doesn't will no longer rely on how much money your mother has or your partner has or your grandmother has or your church has or you have.
Well, prosecutors and state officials have been getting ready for this change for a while now. The state has already commissioned a study on the possible impact of the Pretrial Fairness Act. Well, I talked with David Olson, co-director of the Center for Criminal Justice Research at Loyola University of Chicago, about their work. Now is Professor David Olson from Loyola. David, good to see you. Appreciate your being with me. So let's talk about bail. You guys have done so much study in this for the state. The purpose of bail, it's supposed to be about keeping dangerous people locked up and being sure others return for their hearings. But in your research, you actually have found that bail is imposed for a broader range of purposes.
Yeah, when we've talked to practitioners, we've heard that there's a lot of goals with respect to bail being imposed. In theory, it's about making sure that people show up for court or ensuring that individuals that are dangerous aren't released. In reality, oftentimes it's used for things like ensuring that there's money available to pay any fees or fines that may be imposed. Sometimes it's just a matter of normal practice that we always require people to post some money before they're released. So there really are a lot of different reasons, and I think that's the most significant thing that we can predict with certainty that's going to happen when this law goes into effect, and that's that money will no longer be collected from people in order to secure their release.
And we'll talk more about that. But first here, everybody, when they think about this issue, their mind goes directly to violent crimes and the statistics we read from weekend to weekend. Your research goes to say that's probably not the best way to look at things, but perhaps just as importantly, you note that the percent of violent offenses it's only about 24%. The vast majority of crimes are property crimes, about 75%. So how do those statistics relate to the imposition of bail?
Yeah, I think when people think of someone charged with a crime, immediately their mind goes to the most serious crimes because those are the things that we hear about the most. And so when they hear that someone who's charged with a crime is going to be potentially released from jail pre-trial, immediately they think about the most serious crimes. But as you point out, and as the work we've done tries to illustrate, that most people arrested and charged with crime in Chicago and throughout the rest of the state are charged with crimes that don't involve a victim. It may include drug possession offenses or minor thefts or things like that. So we have to recognize that the people that are arrested and charged with crimes are usually charged with relatively minor offenses. It's those most serious offenses that people think of automatically about.
And we also read a lot, depending on which side of this you're on, you read a lot about the people who are, appear to be in incarceration for years and years because they can't come up with bail. Your research points to a couple of different things. Number one, cash bail resulted in much less pretrial detention than most people assume. You also find that a lot of people who are in detention are only there like a week or less. Not that that's good, but it's not the years that we read about.
Yeah, and I think that's the thing that's important for people to realize is a lot of people are concerned about what this law will do without knowing what our current practices already do. And that's what we've been looking at prior to the law going into effect is what do current practices look like? And what we found is that most people who go through bond court are either released on their own recognizance because it's a minor offense and the judge isn't concerned, or they have to post money, and most do within a relatively short period of time. There are people that are charged with much more serious crimes that have much higher bond amounts that they're required to post. You'll hear on the news someone's ordered to $5 million, to be released. Obviously, they don't post that and they remain in custody until their case is disposed of. Those can take years, depending on the seriousness of the case. And there are, from time to time, you'll hear about cases where an individual is charged with something relatively minor and can't come up with a few $100s, and they'll remain in custody longer than most people would assume. But for the most part, when people are awaiting the disposition of their case, they are in the community.
And indeed, a lot of people talk about the racial disparity and the imposition of bail. You did research on that, and actually your statistics show that Black and brown defendants do get higher bail than whites.
Yeah, it depends on the jurisdiction, depends on the types of crimes. One of the things we found in one of the counties that we're studying is the amount that defendants were required to pay was no different between whites and Blacks. Where the difference really emerged was their ability to pay that, right? So the dollar amounts might have been the same, but the white defendants were more likely to be able to post that money, and minority defendants were less likely. So again, it's a complicated thing to look at when you're looking at what factors drive the decisions about whether or not to impose bond and how much. Usually what it falls to is how serious is the crime from a legal standpoint and whether or not the crime involved any violence. And those are the two strongest things that explain the amounts that people are required to post.
And let me build on that a little bit by looking forward. Given that the purpose of bail is a detainable offense, meaning, public safety and willful flight, what did you learn about bond decisions going forward that may change under the no cash bail provision?
Yeah, I think the biggest thing that's going to change is that there'll no longer be this, I'll call it like a gray area. The way it currently works is people are either released on their own recognizance, they don't have to post money, or they have to post money, and of those, some do and some don't. Under the new law, it's either going to be you're released or you're held. And so what we suspect might happen is for some defendants or for some types of crimes, they're going to be more likely to be detained in jail pre-trial until their case is disposed, because previously many of those individuals might have been able to post money. At the other end of the continuum are people that currently are having to spend maybe a day or two in jail until their family can post the money. Those individuals will no longer spend a couple days. They'll be released as soon as they go before a judge who sets conditions of release.
The reason it's so important to talk to you is because, again, a lot of this research you're not just doing for your pleasure. You're doing this because the state wants to know what you're finding. And so, look, September 18th, cash bail goes away. That's when this procedure can be implemented. What is on your plans with your research colleagues to look at starting at that point?
Really, what we're going to start looking at is how does this change the outcomes at these initial appearances? We have a good sense from the research we've been doing prior to the implementation about how many defendants are released on their own recognizance, how many are released after they post money, and how many stay in jail for a relatively long period or until their case is disposed. What we'll be looking for is how has that changed? And a lot of people are projecting or predicting what will happen. Like I said earlier, the only thing we can guarantee is that people will no longer be posting money. Will more people be held in jail? Will fewer people be held in jail? That we don't know, and we can't necessarily predict because we don't know how the practitioners are going to actually apply this law across the different counties in the state. It may be that there are some defendants that are going to be held in detention for the duration of their case that previously would not have been because they would have been able to post the bond that was required.
Well, Professor David Olson, thank you for the work that you've done that helped the state sort of get its act together about what they wanted this plan to be. But more importantly, thank you for the work you're about to do when this gets implemented and we keep an eye on exactly how successful it is or what kind of problems arise. Your work is going to be critical to that. We're going to keep in touch with it and continue to talk to you. Thank you, sir.
Thank you very much.
Still to come on WGN-TV Political Report, lawmakers say they're concerned with the governor's move to cut some health care coverage for non-citizens. But will they move to reinstate that program? Don't go anywhere.